Good morning, bonjour, Annie. Welcome to the Investor Ready Program Intellectual Property 101 with Smart and Bigger LP. My name is Kimberly Wahama Deshane, and I'm the Operations and Events Manager with Northern Ontario Angels. And I'm here with my colleague, Katie Law, our Marketing and Events Coordinator from Manitouwadge, who joined NOA this week, and our Executive Director, Ian Lane. We will begin this Investor Ready program by acknowledging that we are meeting virtually on Indigenous lands that has been inhabited by Indigenous peoples. We acknowledge all of the treaties and traditional territories on which all of you in attendance gather today. If you haven't already done so, please mute your audio and video channels, and following the presentation, you can unmute or ask questions in the chat. The Investor Ready program is a partnership between Northern Ontario Angels, the Business Centre, IION, and the City of North Bay Economic Development Department. This program is a comprehensive entrepreneurial training program designed to equip you with the skills, knowledge, and tools required to create compelling business propositions and attract potential investors. Now over to Matt Doherty, manager of IION, to introduce our speakers from Smart and Bigger LP today.
Thank you, Kimberly. It's a pleasure to be here this morning with everyone. It's also my pleasure to introduce our two featured speakers of today. The first is the principal of Smart and Bigger, Tony Orsi. Tony assists clients with evaluating new technologies, pursuing patent protection globally, providing strategic IP management services, and developing in-house IP programs. He works in various technology areas, including electrical, biomedical, fintech, AI, software, clean tech, and mechanical innovations. Tony also has practical experience working with ASICs as well as signal and imaging processing. He works with small, mid, and large-sized corporations, universities, research institutions, and commercialization organizations, as well as individual inventors. He advises, mentors, and speaks on IP for several organizations, including the Spark Center, Invest Nova Scotia, the Northern Ontario Angels, and various zones at Toronto Metropolitan University. Welcome, Tony. The next speaker is Christy Bates, Senior Associate at Smart and Bigger. Christy has a broad practice in the licensing, protection, enforcement, and acquisition of trademarks, copyright, and confidential information. Christy's expertise encompasses trademark portfolio management, prosecution, and continuous work, as well as trademark and copyright litigation, copyright advisory work, and transactional IP work. Without further ado, I will pass it over to Tony and Christy to begin their presentation.
Thanks, Matt. Hi, everyone. Really happy to be here to go through IP 101 with you. Hopefully, we're going to give you some good tips and tricks for your toolbox so that way you know how to best develop, manage, and leverage your intellectual property. So, of course, we are lawyers. So the first thing we have to do is give a disclaimer. Otherwise, it'd be a massive disappointment, and we wouldn't be real lawyers if we didn't start out that way. So the purpose of this presentation is really to provide you with information, that toolkit that I was referring to. We're not giving you legal advice. The nuance is that law, it really is very much fact dependent. So it depends on the specific situations and the specific problem that you have. And so it's really important to realize that you should consult with a lawyer as opposed to necessarily taking what we have to say as this is the absolute rule every single time, because there can be nuance. What we're going to be doing is a high-level overview, and it should equip you really well, but always consult with a lawyer about your specific situation if you have questions. One other thing that we wanted to highlight is for those of you who might have heard of Bereskin and Parr, that's where Tony and I worked as of a few weeks ago. There has been a merger, and we are now part of a firm called Smart Bigger. All of the Bereskin and Parr BNP people have pretty much joined Smart Bigger, so it's business as usual. And now, as our name would suggest, we are bigger in size. We're now the largest intellectual property firm in Canada. And we have offices across Vancouver, Calgary, Toronto, Waterloo, Ottawa, and Montreal. And as part of that, we're also part of the IPH network. So IPH is an intellectual property services organization. It's a network of firms in 26 jurisdictions. So it's really helpful if you are looking at, we're really well equipped now to facilitate advisory services in all these different countries highlighted on the map. So just wanted to flag that for those of you who were familiar with the Breskin and Parr name. So let's actually get into it now. So I always find that it's helpful if we start off with an example to make it a little bit more concrete. So throughout our presentation, both myself and Tony were going to be referring to the Hops to It Brewery. It's a brewery that is located, it's hypothetical, it's located in Sudbury. And what they do is they brew beer, they have a brew pub, restaurant services. They're also into merch. So they've got, hoodies, they've got branded cups, they've got branded beer bottles. They're in Sudbury, but they want to expand to the US, maybe even Europe. And they're also have come up with some pretty unique ingredients and some really efficient brewing processes. And so they're at that initial stage of thinking about, okay, what IP is there? What can I do to protect myself? What can I do to leverage these assets that I'm developing? And so there are certain key categories of intellectual property. The first one is trademarks. That's where you're protecting the brand. And that's what I'll be speaking to largely. Then you also have copyright. That protects original expressions of ideas. And then you have other things like industrial designs, trade secrets, and patents. And Tony will be speaking to those in more detail. And a lot of these things can coexist. Sometimes you can have something and obtain, let's say, copyright and trademark protection for the same thing. But because the rights are different, you get different types of protection. So it's really important to understand the different types of intellectual property. So let's start with brands, trademarks. What is it? A trademark identifies the source of the products or services. So, you're driving down the highway, you see the giant golden M, the golden arches, you automatically think McDonald's. You see that symbol, you're thinking of the goods and the hamburgers, the coffee, the products that they have and the services that they offer. And so really what a trademark is, it can be, we're going to go through the different types of trademarks, but it's a sign or symbol that you see and it makes you think of the company behind it. It's kind of like an arrow. And so there are a lot of different types of trademarks that you can obtain. So the most simple ones, the ones that provide the broadest protection, those are called word marks. And so a word mark is just a word. So let's say you got coffee crisp. If we go back to our Hops to It Brewery, Hops to It would be an example of a word mark. And that's just where it's just the plain words on their own. You can also have slogans. So that's a bit more of a sentence. So think you've always got time for Tim Hortons, diamonds are forever, just do it. So it's where you've got a bit more of a phrase, but that phrase is still very closely associated with the source. So if you see just do it, you automatically think Nike. And then you also can have logos. So that's where you are dealing with a design element. So let's say the golden M arches of McDonald's, or it could be a combination. Let's say the Petro-Canada example in the middle. That's where you have a design portion, but also words. So a logo there always has to be a design element, but you can also have words as part of it. And then what's really exciting is that now, especially since 2019, when our Trademarks Act had a bit of an overhaul, there are more and more unique and interesting ways to obtain trademark protection. So for example, things like the shaping of goods or modes of wrapping and packaging. So think of the very unique Toblerone case that sort of looks like a mountain. You see that packaging, you automatically normally think Toblerone. If we go to our Hops to It Brewery, let's say they come up with a really interesting looking bottle. Like obviously, if you think of an analogy, the Coca-Cola bottle, like the first, you see that bottle shape and you automatically think Coke. So there's also, if you have unique ways of, let's say, packaging your product, that is something that could obtain trademark protection. You can even have things like sound marks. So that's where, think of the Metro-Goldwyn-Mayer lion roar. Or nowadays, a more modern example, think of the Netflix sort of boom, boom, you hear that, you automatically think Netflix. And so these are different ways that you can actually go about creating goodwill, creating brand recognition. And the Canadian trademarks law has changed, so that way you can take steps to actually solidify your protection for that as well. So it's just important to realize that there are a lot of different ways that you can obtain trademark protection in a lot of different ways. And normally, as a business strategy, you want your products to really stand out in the marketplace. That's how you get people seeing your product, knowing to buy it. And so it's important to think of the different ways that you can try and set yourself apart from your competitors out there. And these are some of the different things that you can do in your branding and obtain protection for it in order to have that unique aspect. Now, it's also important to realize that not all trademarks are created equal. There are really great trademarks and there are really, I'll just say, bad trademarks. Now, I'm saying that through the lens of a trademark lawyer. Because often trademark lawyers and marketing departments, we can have very different ideas as to what makes something a good trademark. So from a lawyer's perspective, what you'll see on the far left-hand side here is strength of trademark going up. You see the best ones are fanciful coined words. So what's that? That's a made-up word. That is something where you choose a trademark, let's say Xerox, and it doesn't mean anything. It's just something that someone has invented and you associate with your product. And that's really great from a trademark law standpoint because, again, you're unique. It's not descriptive. The more descriptive it is, as you'll see if you look along the other axis, the more descriptive, the more generic it is, the weaker your trademark is. So for example, sharp for TVs, it's descriptive that you're going to see a sharp image. And so it's going to be really hard to actually be able to enforce your rights or to be able to obtain a registration. Why? Well, it comes down to basic policy reasons. When you have trademark protection, it's like a little monopoly. And if you're going to have a monopoly, that ability to exclude other people from using that word or that symbol, it can't be for something descriptive because that wouldn't be fair. If a company could prevent a TV company could prevent all other companies from, let's say, using sharp when talking about their TVs, then that would be an issue. It's a word that other people in the marketplace should be able to use. Whereas Xerox, yeah, you can have a monopoly over that. No one else is going to be using that word because it's not descriptive or suggestive at all of what the products and goods are. And again, from a business strategy standpoint, you want something that is unique, that stands out in the marketplace. So think again, Apple with computers. There you have a word. It's a word. We all know what it means, but you don't normally associate it with computers. And so that's a good example of again, a strong trademark. Or think Amazon for delivery services. Again, we all know what it is. It's kind of suggestive of this like river that like branches out to a bunch of different areas, but it's not descriptive. You can also have things like Microsoft, which is suggestive of microcomputer and software, but again, it's a coined term. So when you're coming up with when you're ideating, you really want to make sure, even though sometimes the marketing team might say, oh yeah, let's make it descriptive, that way everybody knows what they're buying. You really don't want to do that for your trademark. It's really, really important that you come up with a trademark that is unique and not descriptive. And the other thing that you need to do before you go too far down the road of committing to your trademark and your brand is you want to do searches. So what a search does, and there are different categories, but I'll just broadly explain why you want to do searches. In Canada, how trademark law and rights arise is whoever is the first to use a trademark in Canada is really the one who has the right to use it. So for example, what is trademark use? So if I open up Hops to It Brewery, I've got Hops to It on the sign outside my brewery, I've got labels on my bottles, that constitutes trademark use. Once it's on the product, once it's on my advertising, boom, I start gaining rights without even having to do anything further. We'll get into that later, but as soon as you actually start using your trademark on your products in association with your services, you start getting rights. So that's why it's important that before you commit to a brand, you want to make sure, has someone beat me to it? Is someone else using a confusingly similar mark and was doing so prior to me? And you also want to check the register, the trademarks register, to see whether or not someone is actually taking steps to file for a register or mark. And so now I'll talk through the different types of searches that you can do and what each one allows you to assess as to what's going on in the marketplace. So a preliminary knockout search. What that is, it's the cheapest type of search that you can do. And you can do this yourself as a first step. If you Google, let's say CIPO, CIPO, trademark search, you can probably do a knockout. Again, it's likely not enough, but at least as a preliminary step, we recommend doing it. So if you go to trademark search, CIPO, you can then under TM search, just put the name of, let's say, the trademark that you're considering. And that's going to tell you whether or not there are any other marks on the register that are identical to the trademark that you want to use. Because if there is, and it's for similar types of goods and services, you're kind of dead in the water. It's not worth fighting it. Don't go down that road. If someone's already gone to the time and expense of filing for a trademark and you want to use the same one and it's for similar types of goods and services, you're probably out of luck. Or you can speak to a lawyer who, again, can assess the more fulsome situation. But you can also do register search. So what that does is it's not just looking for dead hits, so exact hits. It's instead looking for, are there trademarks out there that are not just exactly the same, but are similar in idea suggested or similar phonetically? Because even marks that aren't visually identical, but might be phonetically identical, if they're for the same goods and services, that can prevent you from being able to register the mark, or that person would even potentially be able to go after you for trademark infringement if they have a registration. So the register search, it's a little bit more fulsome. A full search, that's when it's the full kitchen sink. Not only are you looking at marks that appear on the trademark register, but you're also looking at common law uses. So that means use in the marketplace. So you're looking at business name directories, you're looking online, you're seeing, okay, what is out there? And oftentimes we recommend doing the full search before companies engage in their full branding process, because if there are going to be issues, it's much cheaper to find that out as early as possible, as opposed to at a later stage. And basically the purpose of this is in order for you to assess how easy is it going to be for me to register my trademark, and also what is the risk of me receiving a cease and desist letter from someone saying, uh-oh, your mark is too similar to mine, you need a rebrand. So searches are a really, really good preemptive step that you can take. Another point that I'd like to highlight is confusion. So confusion obviously is a really key concept in the world of trademarks, because if someone has a trademark registration or has prior use of a mark, they have rights in those marks. And the Trademarks Act says that you cannot use a trademark that is confusingly similar with someone else's mark. When assessing confusion, it's a number of different factors that go into the mix. So one, you consider the similarity in the marks in sound, appearance, and idea suggested. So sound, that's where you're considering, are they phonetically, do they sound the same? So think of homonyms, because the thought is, if services are offered over the phone and people can't actually see your mark, they just hear it, could there be confusion? Appearance, that's pretty obvious. So that's where you're just looking at the visual aspects of the mark. Do they just look the same? Idea suggested is more nuanced. So that's where you're thinking, okay, is the idea that the two marks convey similar? And so for that, let's look at the Captain Morgan, Admiral Nelson example that we have in the bottom right-hand corner. So at first blush, you know, they look similar, but they're also quite different in a lot of ways, right? One says Captain Morgan, the other one says Admiral Nelson. Okay, so we both have sort of ship rankings names, and then followed by a last name. And then we also then have original spiced rum, premium spiced rum. That's kind of descriptive, so no one really can claim a monopoly over that too much. But then we also have these pirate-like or admiral-like characters who are in their sea garb and, you know, are taking sort of authoritative stances. And ultimately, in this particular case, the court found that these were confusing, that these characters, even though there's a lot of different elements, ultimately the idea suggested you're assessing it from the perspective of a consumer in a hurry. So it's just a quick glance. Do you think that they could be related? You don't necessarily need to think it's the same mark. You have to, the question is, could you think that there is an association between these products, that they come from the same source? And the court ultimately in this instance found yes. So I think this is a really helpful example to say, you know, you can't just do little tweaks necessarily to differentiate yourself from your competitors, especially if you're operating in the same space. It really has to be quite distinct, different branding. And just using different words sometimes isn't enough. There has to be more to it than that. And again, that's where a lawyer can help guide you through that process. And then also the example on the left there, that's the Swiss marks. Should look familiar. It's basically the Swiss flag. And in this case, yeah, a clear instance of they found confusion between the marks, even though arguably this is something that is pretty generic. So all that to say, it's really important to get advice and to consider the similarity between the marks. And if the goods and services are the same, that really increases the risk significantly. If you've got the same mark as someone who operates in a completely different space. So let's say on the one hand, I've got a trademark for stuffed toys, like kids' toys. And then there's for, we'll call it owl time, just random word. And then someone has a herbicide branded owl time, not an issue, because stuffed toys and herbicide are just such different. The channels of trade are different. They're sold to different people seeking different outcomes. So they're very, very distinct. So in that instance, the risk is very low. But if the goods and services are similar, then you absolutely need to be very, very, very careful. Other things that can't function as trademarks that I'd like to highlight. So things that are functional. The Lego case is really famous for that. So Lego tried to obtain protection for the shape of their Lego pieces, and ultimately the court said, nope, sorry. The reason they're shaped that way is so that way the Lego pieces actually fit together. It serves a functional purpose. So you cannot obtain trademark protection for functional, the functional element of something. So going back to the Hops to It brewery, if we had a situation where some Hops to It came up with a bottle that had its shape because it was easier to hold, or there were less drips, or it stayed colder longer, you can't obtain trademark protection for that. You could maybe obtain patent protection for that. Tony will discuss that in more depth later, but that is not the realm of trademark protection. Other things you can't trademark, or at least are very difficult to trademark, are names. So names, generally stay away from them. There are exceptions, but generally avoid names. Clearly descriptive, we discussed that as well. So touchless car wash for car washes, yeah, that's not going to fly. The name in any language of any goods or services. So don't think if you have cookies and you'll use the word biscuit to try and obtain protection, that's not going to work. It's descriptive in another language. It's descriptive of the actual name of the good. And it also can't have no inherent distinctiveness. What does that mean? It means it can't be generic. If you Google it, I encourage everyone on this call Google your brands, like your potential brands, before you even take any further steps. Because if the word's used very frequently in your space, you're not going to be able to obtain trademark protection for it through registration, and or it's going to be almost impossible to enforce your right. So it's really not useful as a trademark. Other things that cannot be registered. So you need to be really careful when you're using the maple leaf. You obviously can't use things like the Olympic rings, official marks, or geographical indications or plant breeders' rights denominations. So those are other things to keep on your radar. The other thing that's important to understand is the life cycle of a trademark. So you start out here. This is, our recommended process. You start out with the search. We discussed that at length just a few minutes ago. So that's where you understand, get a lay of the land. How strong is your trademark? Do we think it's probably going to get registered, or are you going to encounter some issues? You then prepare and file an application. It's really helpful to have a lawyer assist, or trademark agent rather assist with that, because they can come up with descriptions of goods and services that will make your trademark go through to the registration process faster and potentially more effectively, because it might have a broader scope of protection. Examination. So that's when the government actually looks at your trademark and said, do I think that this is confusing with any other trademarks? Do I think it's descriptive? Do I think it's not distinctive? And then they can write a letter to you saying either you're great, golden, your mark's going to go through to the next step, or they say, sorry, I think it's confusing. And at that point, your trademark agent will file written arguments trying to overcome the confusion objection or the descriptiveness objection, etc. Which is, again, why it's useful to do the work at the front end, at the searching stage, because we can guide you then, as opposed to spending money later down the road filing arguments. And also, you'll see there's quite a delay, 20 to 54 months. So you don't want to have invested in a brand, go for a while, and then 54 months later, you get a letter from the government saying, oh, we have issues with your trademark. It's best to find those problems as early as possible through the search. But let's assume you don't have any objections, and or your amazing trademark agent is able to overcome the objections. The mark then gets approved for advertisement. At that point, third party, so as opposed to the government assessing your mark, it's an opportunity for third parties, other people out in the marketplace, to take issue with your application. So let's say if you have a trademark and someone out there was the earlier user of the same trademark for similar goods and services, they can oppose your application. And that's kind of like mini litigation. There's evidence is filed. You see who was the first to use the mark. You assess confusion. You assess all the different factors, and it can be quite expensive. And then hopefully, if there's no opposition, and or if you win the opposition, oftentimes oppositions settle, to be honest with you, then your mark is registered. You have for a 10-year term, and then you have to renew it after the 10-year process. So yeah, it's a lengthy process, which is, again, why you normally want to get your applications filed as quickly as possible. Now, the other, we just talked about the registration process. And as I alluded to before, it isn't strictly necessary to secure a registration in order to obtain trademark rights. As I said before, as soon as you start, slap the hops to it on the beer bottle, put it on the sign, put it on Facebook, Instagram, and you start advertising your brewery services, you start getting rights. The thing is, when your rights are limited to where you can actually show you have used your trademark. So for example, if Hops to It is only selling its beer in Sudbury, its rights only extend to Sudbury. Whereas if it's shipping, it's got a buyer in BC, it can ship, then it might start also having some rights in BC. So that's why the registration is helpful, because what the registration does is it gives you cross-Canada protection, irrespective of where your evidence of use is. So if Hops to It in Sudbury just sells in Sudbury, but obtains a trademark registration, and someone in BC starts using the same mark, then I would be able to, if I'm Hops 2 and Sudbury, I could prevent them from using the mark in BC if I have a registration. If I don't have a trademark registration, I'm out of luck unless I can show I've sold my products in BC. So what it does, it's a really great tool to give you that cross-Canada protection early on. It also gives you additional avenues of attack. So when you have a registration, that's actually when you can sue for infringement. And you can also go for depreciation of goodwill as well. Whereas if you're just relying on your unregistered right or your use-based rights, that's another way to consider it, then it's a lot more work. You need to show you have goodwill. You need to show you have like that you've made sales in the area where the quote unquote bad guy is operating. And it's just a lot. It's much more expensive from a legal cost standpoint to make out a case for passing off based on unregistered rights versus infringement. Infringement, it's like if you have a lawyer writes a cease and desist, it basically says, we have this registration. You are using a mark that is confusingly similar. You have to stop. And then you can settle it. And normally to the trademark owner's significant advantage. Whereas if it's passing off, it's a lot that cease and desist has to set out, the history of the brand. There's a lot more to do. There's a lot more of a burden on you as the brand owner versus if you have a registration, it's much, much easier. So, but do realize that it is, you do have rights even without a registration. And it's important to keep copies of, how you're using your trademark. It's important that you think your trademark should be everywhere. It should be on your packaging. It should be on your website. It should be on your consumer. Like if you, let's say, have forms, services agreement, like you name it, really, you can't put your trademark too many places. You really want it to be plastered everywhere because it really helps strengthen your case if you ever need to enforce your rights against anyone. So I think this is my last slide on the brand strategy. So let's kind of reconvene the thoughts we have here. So first of all, you want to start out with your brainstorming, that ideation process. So you want to consider trademark searches before committing to a brand. It's some money up front, but long-term, way less money spent. From a legal fee standpoint, and also just from if you ever do need a rebrand, that can be very expensive. So again, best to pick a good trademark right out of the gate. You also want to come up with something distinctive, unique. You want to avoid it being suggestive, descriptive, or generic. It's really, really important. Okay, you did your search. It's not a descriptive mark either. You've finalized your brand. You know what direction you're going in. You want to file that trademark application. And then you want to then start marking all your products with the TM or the R in a circle as appropriate. What's the difference? TM, that means your mark isn't registered yet, or it's just not registered at all. So you can just put in the top right-hand corner. You can use the R in a circle once it's registered. But it is really helpful to put markings on your use of the trademark because it's just telling the world, I consider this to be a trademark. And that way it's just really clear that you're engaging in trademark use. If you're considering other countries, then let's say Hops Brewery maybe wants to go to the States, as I said before, Europe, then you also might want to do foreign searching. So searches in the US market, in the EU markets, and then filing international registration. So that way you can obtain protections in those other countries as well. As your company grows, let's say Hops to a Brewery starts, partnering with a food line as well, and so there's hops or selling the hops directly, let's say, then you want to file for more trademark applications that cover all of your goods and services. So it's important that you review your trademark portfolio to make sure you have broad scope of protection. And it's also really important that you take steps to police the marketplace. What does that mean? It means that if someone is out there that you discover that is using a confusingly similar trademark to you, as the brand owner, you actually have an obligation to try and prevent their use. Otherwise, your trademark rights can to put it bluntly, be killed. So if you have a situation where you're seeing other people using, or just one other person using a similar brand name, you have to get on that as soon as possible. Because if there is coexistence in the marketplace, in the same marketplace, or just in Canada, then that really, really can diminish your rights. If you have a registration, that means it could be invalidated. If you have common law, just relying on unregistered rights, then it also effectively means that if you send a cease and desist to someone and they say, yeah, but there's all these other parties that are using basically the same mark, you're out of luck. There's really not much you can do. So there's a concept called genericide as well in trademarks, and that's where a term that you use for your product, it becomes generic of the field. So think of Kleenex. That's also something that you want to avoid, because then you effectively lose your rights in that. So it's important that you stay on top of what's going on around you. So that's it on the trademark side. Tony, I will hand it over to you.
Okay, great. Thanks very much, Christy. That was really informative. And so I guess for the last half of the presentation here, I'll go through trade secrets and patent protection in a bit more detail with more of an emphasis on patents. Now, sort of group these together because if you are looking for patent protection, you basically start off maintaining it as a trade secret. The reason for that is that many patent offices around the world have this, what they call an absolute novelty requirement, which means that you need to keep the invention secret in terms of not giving too much information to the public in terms of how it can be made and how that's related to what you want to protect before you file your first patent application. So many countries have that requirement. The US and Canada, though, do have a 1-year grace period. So if there are some public disclosures that have happened, that you still may be able to file in those jurisdictions. And we'll talk about a few scenarios where those public disclosures might happen. So in terms of trade secret protection, then and patent protection, it's really a strategic choice that you will need to make. If you do want to maintain something as a trade secret, then there's nothing that you have to file with any sort of IP office, but rather you take steps to maintain that secret confidential. So basically that's done through contracts for individuals who who will have, I guess, will receive that information or have access to that. So that could be internally as well as externally, and then also security measures. So putting password protection on files and computers and locks on doors and things like that, and limiting access to that information. So there are pros and cons for each of these, and we'll get into these in more detail in the next few slides. But the other thing for trade secret protection is that basically it can be used to cover more than just inventions. So it could be anything that's of strategic importance and has value to the company, as long as you're able to make it, keep it as a secret. Christy, next slide, please. So with trade secrets, then the idea is that it provides this protection for as long as that information is not in the public domain. And sometimes it could be a good effective use of trying to protect your invention or other sensitive, valuable information if others won't be able to easily come up with this information themselves or reverse engineer it. If they are able to do those things, then this wouldn't be a good candidate for trade secret protection. And in some cases, you may be able to sort of extend, this protection or this advantage that you have compared to, let's say, patents, for example. So patents have a 20-year term from the filing date if you're able to get an issued patent to prevent others from making, using, or selling the invention in a country where you have protection. So at that end of the 20-year period, it effectively goes into the public domain. And also for patent applications, they are published eventually, and so they contain information on how the invention is made and how it operates, and so that would also be available for others to read 18 months after the earliest date that's tied to that patent application. Whereas with a trade secret, then if you're able to maintain this advantage for longer than 20 years, then that could be something to think about. And a great example of that is the Coca-Cola formula. But it's also used in conjunction with other types of IP rights, as Christy had mentioned. They protect your IP in different ways, and different aspects of the IP, and so together, they could provide even stronger protection. So for going back to Coca-Cola, they've of course have built huge brand and lots of goodwill with the marketplace. And so even if others might be able to make something which might, kind of taste a bit similar, people that, still, prefer Coke. And you may remember those taste challenges between Pepsi and Coke. I think maybe back in the 80s, I guess it was now, 90s. But yeah, you can see the strength of brand value and using that along with trade secrets and potentially patents as well. So with trade secrets, then to finish this piece off, there are some risks. So basically, if there's any sort of disclosure, whether it's on accident or not, whether it's by accident or not, once that information's out in the public domain, you can't do anything to sort of take it back, and your trade secret protection would effectively end. There's also risks from employees who leave or other collaborators if they may, take that information and use it and somehow. And then also with respect to independent discovery, if you're maintaining an invention, let's say as a trade secret, someone else is able to come up with it on their own, because you've been keeping it as a secret and assuming that, this hasn't been out in the public domain at all, the other party might want to file for patent protection, and you wouldn't really be able to stop them. Next slide. So moving on to patents now, these come in two different variations. So the first that we'll talk about are referred to as design patents in the US or industrial design patents in Canada. And this type of patent is used to protect the appearance of a good in terms of some aesthetic features. So basically, how it looks, the shape, ornamentation, for example. And here, what you're trying to do is, if you go for this type of protection, you want to be preventing others from making similar articles that look, very similar to what you've got protection on. And this could be very important in, the consumer goods field, for example, where people may be more likely to purchase something because of the way that it looks. So, you can think of more traditional things such as, furniture, clothing, or, vehicles, but these can also apply to virtual items as well. So you can think about graphical user interfaces for apps, for example, as well as icons and perhaps some simple animation. So if you want to pursue this type of protection, you would need to put together a patent application and file it with the patent office in the countries where you want to have protection. And again, you've got this absolute novelty requirement where you need to keep the design secret before you file, although again, some countries give grace periods under certain circumstances. And basically the application here would primarily consist of figures which show the design, the good that embodies that design from different views, let's say. So this could be important in some situations. The protection is more narrow and focused on what you have in the figures. And if this is something that's of interest, you would think about this later on in the design stages, where initially, you're trying to get a prototype working, or the initial designs done. And then, as you start to get closer to the actual product launch, you may start to think more about the user experience and so on, and some changes may be made at that time, and it would be those things that you might want to capture in applications, and maybe even some other designs which look different and could still provide value if you don't want others to be able to have to be able to use that design themselves. Next slide, please. So some examples here, keeping in line with our example, a hypothetical example of Hop to its brewery. Here's a couple of examples of actual industrial designs in Canada that have been registered. The one to the left is for a beer bottle, and then the one to the right is for a beer keg. And so these are just examples of a couple of the views or figures that were in those applications. And another example, of applying designs to more of a virtual object. You see that there's this graphical user interface showing a medical image. And one thing to keep in mind here is that if there are any aspects of the design which are optional, you could show them using dashed lines. And that could also be a way of, making the protection broader, because otherwise for someone to infringe, they would pretty much, need to copy everything which is shown in solid lines. So again, this is, a different type of IP right applied for on a country by country basis, and having, a limited term of protection. So 14 or 15 years from the filing date. Now moving on, the other type of patent, which we most countries refer to as utility patents, protect an innovation from a different perspective in terms of trying to protect the structure, and or functionality or composition of the invention, depending on what it exactly is. So again, just like with design patents, you've got this absolute novelty requirement, where you need to keep the invention secret until your first filing, but there are some countries with grace periods under certain circumstances. And for this type of right, you also need to put together a patent, like an application, which describes the invention. And really, it's a combination of figures and text, and providing enough detail so that somebody skilled in the art can read the application or the issued patent, and be able to figure out how this works. This is the sort of the bargain that the patent office makes with the the patent holder, in that the patent holder would get a monopoly for what they're able to protect, which is described by sentences called claims at the end of the patent, describing something which is unique compared to what's in the public domain previous to the filing of the application. And, so to have that right, the patent owners then would have to disclose how the invention is made. And, this is done on purpose because it's a way to further innovation. So somebody could read, these patents and think of ways to improve on them. In fact, a lot of patents do go to improvements for previous, technologies or products and such. The other thing as well, again, with IP rights in general, is that they are country specific, and of course there's a time limit tied to them as well. Next slide, please. So one of the things where utility patents are stronger, let's say, than design patents and even trade secrets for that matter, is that they do protect against independent invention. If you're able to get that patent filed and before someone else has come up with this and get it issued, then you would be able to prevent them from practicing the invention. And if there's two parties who did try to come up with the same invention and file for protection, it would be the one who files first. So there's a bit of a race to the patent office in that respect. However, on the other hand, you want to make sure that you're not filing too early either. So in some cases, the innovation is still being developed, and you wouldn't, you could file early before it's completely finished through what's called the US provisional. But then if the invention does change quite a bit afterwards, that application may not really provide value. And that's what the name of the game is here, especially for startups, is that you want to be looking at these IP rights which provide you with value, add value to your company, would make your company more attractive, let's say, to investors, for example, or to potential partnerships, in terms of showing that you have some expertise in some areas of technology or products or whatnot. And so this is what you always want to be thinking about when you're trying to decide whether or not to pursue IP rights. And so for patents, you want to look at what is unique about what you've created that also overlaps with your competitive advantage. Why consumers in the marketplace would want to purchase your goods or services versus others. And another thing to think about is how broadly can you protect the invention. So you may hear from people that it could be easy to get around an issued patent, and the answer is it really depends on the situation. So sometimes the claims which describe the protection are very narrow, and it could be easier to design around it. But the thing is, you want to try to determine this up front so that you can decide, whether it's worthwhile to proceed with patent protection. And if you do, there are several criteria that need to be met. which are generally the same across the various patent offices, although there may be some nuances in some of the countries relative to others. So the criteria basically would be whether the invention falls into one of the categories that a patent office would grant protection for. So we refer to this as the statutory subject matter criteria. And as an example, you wouldn't be able to protect an idea or a theory or a scientific principle or equations, but rather you'd be looking at implementations or what we call embodiments, which describe how this invention would be reduced to practice, basically built or realized, and it has some sort of practical use and practical application. Software, is in a gray area here where it is more difficult to protect software-based inventions. And we need to look into things in more detail there to make sure that, that there's enough there to meet the patentable subject matter criteria. Novelty and inventiveness, so basically relate to the unique aspects of the invention. And this is with reference to what's in the public domain. So basically, things that are in the public domain with a date that's earlier than your filing date. And we refer to that collectively as prior art. So novelty means, these elements, or maybe, how they relate to one another, have to be new compared to what's in the prior art. So there isn't one document which describes, all of these things that you want to protect. And then inventiveness is a bit more challenging. It's more subjective in that an examiner can combine two or more prior art references to try to piece together the invention, let's say. So there are ways to counteract this, and you want to consider it early on as well when you're making the decision, and thinking about if you're able to solve a problem that no one else has solved, or if your solution has some advantage compared to other solutions. If it's taken you a long time to come up with the solution, the invention, these could be things that could point to it being non-obvious or inventive. And then finally, there has to be utility, and the invention has to work. Okay, next slide, Christy. So in terms of, trying to determine whether you meet the novelty and inventiveness criteria, you could do patent searching, which is, looking through the prior art. And that could be done various ways. When we do this, we focus more on the patent databases. And basically, the prior art can come from anywhere in the world. So if you want to protect this in the US and Canada, you still need to be, aware of prior art in Europe or Australia, for example. And when you do this searching, it's not 100% guarantee that you found everything which is relevant, because again, the prior art can come from anywhere in the world. And also patent applications are kept secret for 18 months. So when you're doing this, you'll hopefully get enough information to make an informed business decision, but it should be understood that there's never a 100% guarantee that you're able to get a patent at the end of the day. And so here, the purposes of searching would be patentability that, we just discussed, but also freedom to operate, which means, looking for issued patents in countries where you want to commercialize, where the claims, the protection for those patents can be broad enough to cover what you want to commercialize. And this might happen, if you're innovating on a previous technology, for example. Next slide. So in terms of the filing strategy, there's a few different things to think about. The type of application. So as I had mentioned, you can do a temporary application, which is a US provisional. So you get that initial filing date. And then you have a year to basically further refine the invention, maybe add, get data on how well it works, and then you can include all of that into what we call a full patent application or non-provisional. But the thing is, with a US provisional, again, it has to, pretty much describe the invention, most aspects of it, to provide you with value so that you could rely on that earlier date. But otherwise, though, if you are certain that the invention's finalized, you could move to doing this full application on a country by country basis. Another option is what's called a PCT. So that's an international application, which basically delays when you have to file in the actual countries. But there's no such thing as an international patent. And in terms of the countries themselves, primarily you're looking at the biggest markets for for your product, for what you're patenting, and where you're going to be commercializing. Other things that you could look at would be where, competitors might be interested, or potential partners, maybe where manufacturers are as well. And of course, it's very important to consider your budget because these costs do escalate quite a bit once you start to go international. Another important thing to think about with respect to patents is that there's a difference between inventorship and ownership. So inventors would be individuals who are involved in, coming up with the unique aspects that are going to be in the claims. So, it's not like authorship, in a technical article, for example, where you might include somebody out of, I guess, a sign of respect, for example. But here it would be people who actually make creative contributions. So if somebody is doing testing on the invention and they just report the results of how it performs, they wouldn't be an inventor. But if they come back, and they review those results and they make suggestions on how to make the invention better, and those things make it into what ends up being protected, then they would be an inventor. An owner, could be different than the inventor, and typically are. But if inventors were doing this just on their own and they don't have any contractual obligations to others, they would be the owners. But typically they're employed by a company, and part of their job function is to do R&D, and which could lead to inventions. And they would have signed, an employee contract where they agreed to assign their ownership rights to the company. So in that case, it would be a different entity who's the owner. And also, the ownership can be transferred by paper assignments. Next slide, please. Yeah, we're just a few minutes left here, so I'll just go quickly here now. But basically this slide, and I think the people who are attending will have access to the slides. So, you can review this as well on your own time. But here again, when you're first starting off, the budget is limited. So you want to focus on the really valuable products and technology that you've developed that you want to commercialize, and the countries which are most important to you, and sort of keep the filings to a small number. And then as you start to increase your budget, you can start to think about maybe filing in more countries for other patents, and trying to build more of a fence around your technology. So these additional patent applications could be for inventions which sort of build on or expand the core technology. And then in terms of best practices, you always want to keep good records to make sure who's involved, have these agreements ahead of time so that it's clear who the owner of the IP would be. Keep an eye on competitors, and you could use the patent searching as a source of competitive intelligence, for example. And then also, it's important to make sure that you're reducing your risk and considering freedom to operate. So again, that's where you're looking to see if there's patents with claims that are broad enough to cover, what you want to commercialize. And if there are, there could be ways to deal with that. And we just listed a few there. Next slide. So yeah, getting back to the example then, for Hops 2 at Brewery. So, the ingredients that they're using, there could be something which is, novel and non-obvious there, maybe in terms of the processing, for example, too. Or it could be something that you may want to keep it as a trade secret. The bottles themselves, or the kegs, for example, again, if they have a special structure which can have some advantages, you could look at protecting it through a utility patent, or just in terms of the shape, looking to see for design protection, even for the clothing and the swag, those could have unique appearances that you might want to protect through designs. And of course, you're considering the main countries where you're going to be commercializing, and considering the budgets for that ahead of time. Christy, did you want to take this slide here? Or no, this was, okay, I was going to finish off on this, sorry. Sorry about that. Okay, so yeah, getting back to what we mentioned earlier about being careful about public disclosure when it comes to patents, talking about your technology, if you're looking to protect it with a patent or maintain it as a trade secret, there's lots of I guess events or interactions with the public where you need to be careful in terms of what you say. And a lot of times, startups, might be involved in pitch competitions, for example, where you do want to talk about the tech a bit, and maybe the IPs as well. But it's very important to maintain the description of the tech as a black box. And you don't have to go into a lot of details about the IP, but rather just sort of signal to the crowd and maybe potential investors, that this is something which is part of your business plan, that you have been thinking about the IP strategy. There could be some aspects that are patentable that you're going to be pursuing, or maybe you've already filed and you're in the process of protecting this technology through patents. But yeah, the take home message here is just be very careful about what you tell others, and be careful not to disclose anything which could prevent you from filing a patent application, or could jeopardize your ability to maintain this as a trade secret. Next slide.
Okay, I can jump in here, Tony.
Yes. Thanks.
So for IP due diligence, that's also something really important to keep in mind, because if your company, if you're going to be getting investments, or if you're going to get bought out, they're going to be doing, without a doubt, IP due diligence. So for that, you want to be prepared, and it's better to be prepared and get into best practices from day one, because it's a lot easier to do it as you go along as opposed to retroactively going backwards. So one, you want to keep an IP inventory. So you want to definitely keep a list of all IP that you own and or that you license out or that you license in. So for that, it's important to just keep a list of all your agreements, and also to go through an IP strategy yourself to determine what IP do you actually have, because that's always going to be asked in a due diligence context, and what steps you're taking to protect it. Make sure inventorship is determined correctly. So get the names, addresses of the people who actually came up with the inventions. You want to track that. You want to make sure that you have, next bullet point, assignments from the inventors as well. Or for, let's say, if you have someone coming up with a website for you as an independent contractor, there's copyright potentially in the website that they create. You want to make sure that the copyright is assigned from the website, the person who created the website, to your company. So you always want to make sure you have IP ownership clauses in place in your company's favor if anyone's creating anything. And so not only do you want that assignment, but you also want to make sure that there are controls in place in terms of what IP can be used by third parties. So even, let's say, with clients, if they are getting some access to something proprietary to you, you want to make sure it's limited in terms of what they can and cannot do with your IP. It's also, if you're in the software space especially, or you're creating software, do an open source software audit. Open source software, there can be limitations in terms of what you can do. So let's say copyleft is the idea where you might be able to use someone's open source software, but you might not be able to use that software in a commercial context. Or there might be certain requirements that you have to disclose any code that you create that like modifies the underlying source code. So it's really important that you understand the limitations and permutations of the open source software that you might be doing. And there are third-party service providers who can assist with open source software audits. You also want to be in a position to discuss the strength of your IP portfolio. So you can guarantee people are going to ask, do you have trademark applications pending? What steps have you taken to ensure that your trade secrets remain secret? So you want to just make sure that you engage in good practices there and are ready to speak to it, and therefore document it as you go along and as your business grows. Quality also is definitely key over quantity. There might be, a million novel little things that you're doing, but what is the secret sauce that makes your business special? What's the critical aspect? So it's important that you prioritize and spend the time and effort on the high value IP. And again, a lawyer can definitely help walk you through that process. And then also be ready to articulate future plans for using your current IP and creating new IP. It's not just sort of survival mode all the time. It needs to be forward thinking. So whether you license it out, whether it's revenue streams, who knows what, but you just want it to always be thinking a few steps ahead. And then it's also important that you realign your IP strategy with your business goals as your business evolves. So oftentimes when you're near the end of your products in the market is doing well, branding actually can become incredibly important. Whereas at the beginning, sometimes people put a little bit more effort into that. So it's important that you're constantly reassessing. And as noted, yeah, your IP firm can absolutely help you through this process because it's complex stuff.
Okay, great. And this is the last slide here. So, sorry we've gone over time, but yeah, just bear with us for a few more minutes. This is, important to consider as well. So there are various IP funding programs that are out there that have been set up to support startups and, pay for certain types of IP services. So, I won't go through these in detail, but there's IP Assist, which is a federal program that's put on through NRC, but it might also be available through, the regional innovation centers as well. And this would cover, excuse me, IP education and some, of the background work that would need to be done, in terms of perhaps looking at, competitors and what sort of IP rights that they've applied for. Elevate IP is also a national IP funding program, and it covers more than IP Assist, but also covers IP education and strategy. But can also cover things such as drafting and filing of patent and trademark applications. Although again, depending on the organization which facilitates this, which is different, in different areas of Canada, there could be some co-pay requirements that exist there. And then in Ontario, there's IP Ontario, which is also a really good program, quite similar to Elevate IP in terms of what they support. And they've also just expanded, I guess the different types of technology that they would grant funding for. So very good to take a look there and try to get registered if that's of interest. They do have like a rolling call for statements of work for funding, which seems to come out maybe every 2 months or so. So that's something to keep in mind. And then there's some other government programs as well. So Can Export, if you're looking for some assistance with respect to commercializing in other countries, and there could be some IP support there. And then also Innovative Solutions Canada, which has 2 different streams for R&D in certain technical areas. And of course, there could be other programs that could be available too through, the various business organizations. So, the partners on this presentation. So maybe checking with the Northern Ontario Angels or the City of North Bay, the Business Center at Nipissing Perry Sound, and then Innovation Initiatives Ontario North, and also Federal Economic Development Agency for Northern Ontario, just to name a few. There may be some others as well. And so some people from these organizations are in the presentation here. So be good to maybe reach out if you're interested in those. And we can also provide some further information on some of these IP funding programs too, if that's of interest. And with that, that's the presentation. Thank you very much for your time this morning, and we can take some questions now, if there are any.
Thank you so much, Christy and Tony. We do have some in the chat. Okay. Kimberly has one regarding US provisional. If you significantly pivot from the initial application in those 12 months, is this an issue? Can you refile? What is the range in fees for this US provisional?
Okay, so for a US provisional, yeah, it's the value that it provides really is in that early date, because sometimes there may be a public event that's going to be happening, such as a presentation or trade show, or some other interaction with the public, which isn't going to be under an NDA, and so you need to file before if you want to protect in most of the countries, or have the ability to protect in most of the countries. So the issue then is if you pivot and the invention changes quite a bit, then that initial filing may no longer give you, the benefit of that date, because it really should be describing the invention that you want to protect. And even though US provisional doesn't have to have all of the sections as a regular or full application has, it's our position that these should be prepared as high quality patent applications, so that you do make sure that you're getting that date and you can rely on that filing date. In terms of the range of fees for the US provisional, the USPTO filing fees, government filing fees would be about $200 Canadian roughly. And then the firm fees can depend on the complexity and the nature of the invention, how many embodiments, the scope of work, for example. And so ranges could be maybe from 5,000 to maybe 15,000, just sort of generally. And I guess then based on the actual invention can sort of come up with a more concrete number.
Thanks, Tony. Another question. For patents, do I need to have a patent in each country? I want to market my IP in.
So you don't need to have a patent to market the the products or services. If you want to prevent others from making, using, or selling or importing what you have protection for in that country or in a certain country, then you would want to file for patent protection there. But yeah, you don't necessarily need to have the patent to then market yourself. And the other thing too is realistically you won't be able to protect it in a very large number of countries. So you need to be a bit more careful with those countries that you do file in.